Hello, my name is Jay, and I'm the creator of this channel. In 2003, I lost a job for a second time with a very lucrative deal I was doing with doing computer tech work for two different Fortune 500 companies. I lost a job 1 year, and then I lost another job a year later. But this is when my first child was born. He was turning 3, and we started to realize that something had happened in me to make me not conducive to fitting into a construct that wasn't accountable. And so at that point in time, we started looking at what was the deal, what kind of made me tick. We didn't know it at the time. Okay, we didn't know to admit it at the time. But I had endured some things as a child that kind of tainted my ability to process things the same way as other people. And upon losing my job for the second time, I couldn't really get back into the computer tech world again, because the reason I was losing the job was because when I saw unfairness and partiality and things like that, I would speak out against it. Of course, bosses don't like that. They don't want you to point out when they're not following their own rules. So it was time for me to go. And I couldn't keep repeating that pattern. So in 2004, we started into foreclosure. We had 80% equity in our house. I started looking at the terms of the deed of trust and the letter, the letter of the law that was written down there. And for the bank to foreclose on it, they had to hold the note. And I subpoenaed the note in North Carolina, Forsyth County's Superior Court. And Bank of America subpoenaed the bank, and I subpoenaed the trustee, which was Brock and Scott. And neither party appeared and brought the note. Brock and Scott appeared, but they didn't bring the note. They brought a copy of the note, which is not the same as a note. It's not under the best evidence rule. And I pointed that out in the foreclosure, and the clerk of court, assistant clerk of court, Joanne Caudle, who was conducting the backroom hearing, and did not have the proper oath of office to be in office, and I also pointed that out as well. And I found out that in North Carolina, clerks of court across the 100 counties there take a different oath than what is prescribed in the North Carolina statute. So none of them are legit. They're de facto, but not de jure. They're actually in office, but they're not legally and rightfully in office. So I pointed that out as well. Of course, they just rubber stamped the whole deal and went ahead and foreclosed, and we lost 80% equity in our home, and were financially crushed. And that was my primary adult trauma. After I went through that, I didn't want to be a part of society again. I refused to jump back into the saddle, and I started really deeply looking at the esoteric and hidden things of what goes on in the system. And I helped 10 other people with foreclosure cases in North Carolina. The North Carolina State Bar actually wanted to send me a cease and desist letter for unauthorized practice of law, and I was helping these people for free, help them fight foreclosure because they couldn't afford an attorney. And of course, the bar wanted a piece of that action because the bar doesn't like competition. And at one time, I was pretty adept in court. I've got footage on Michael Moore's Capitalism, a Love Story film. You can look at the end credits and look for Jay Vincent and Hezekiah Land Trust, and you'll see those two are listed as a thank you. We sold them footage, sold Michael Moore's Dog Eat Dog Films footage of a foreclosure eviction that was done in Davison County, North Carolina. And they brought a SWAT team out, and it was crazy. I mean, this guy that I helped, a friend of mine, they didn't have a gun. No, but because we had embarrassed them, the sheriff didn't have a proper oath of office, the register of deeds didn't have a proper oath of office, and the clerk of court didn't have a proper oath of office. And we got it certified in writing with a county seal on it, and that just pissed them off. When you embarrass the court, that's what pisses them off. And so that's why I'm going to ask you today to help me embarrass this court in Oregon. These two yahoos, Marco Hernandez and Yuli Yu, have come onto my case. They've come onto my case, and they've acted as if I have no right to be here. And they've prejudiced my case because they've I'm asking them to uphold the Americans with Disabilities Act, and I'm also asking them to uphold the Constitution. These are the laws that they purport to uphold. And they're acting as if I have no right to be here, and the only denominator is that I'm indigent or poor, and I can't afford counsel. I don't really want counsel to represent me, but in their court, they offered counsel to assist, as is prescribed under the Constitution. I said, sure, I'd love counsel to assist me. And of course, they summarily denied that. And they've let me in without paying the fee because I don't have the money to pay the fee. I'm on SSI, and I have no ability to pursue this on my own. I've contacted the ACLU. I've contacted Disability Rights Oregon. I've contacted numerous private attorneys, even the Department of Justice. And all of them say the same thing. Well, we wish you well, but, we just don't have time to chase everything. And ACLU, nothing. Billy Williams, U.S. Attorney, asked for him to get involved in my complaint. Nothing. Had several press conferences between when I filed my complaint to now. Of course, he's chasing people who are, growing pot. Victimless crime kind of shit. I wish I could smoke pot. It would help me out. I can't even take medicine for what I have. It just there's nothing that they can prescribe me that I'm gonna feel good about. So anyway, the court let me in as a pauper, someone who couldn't pay, and then they proceeded to deny me access. I motioned for an attorney. Nope. Asked for auxiliary aides to have a buffer between myself and the court, because it honestly scares me and pisses me off to have to deal with these people because they're so inconsiderate and without compassion. It's a fucking machine. And of course they haven't ruled on that. So now I've got an expert witness that has been certified in many, many cases under Daubert and Fry standards to come in. She's known me for a while now. To come in and testify that I do need auxiliary aides and that I don't trust the court and how I react when I perceive partiality and unfairness. And so what I'm getting ready to do in this response to the court, I'm going to ask everybody here to mirror this video for me, please. It's a long video, but I'm going to link in this video. I'm going to show links to where these documents can be found. I'm putting them online. And I want the court to have accountability here. And the only way to do this is to drag this out in the open and expose it and embarrass them. When a judge comes on, if a judge saw somebody with a disability and they had crutches and a wheelchair and they were a below-the-knee amputee, and a judge said, I'll take their wheelchair, they'll be all right with just crutches. That's the same effect that has happened here. I actually had a doctor write me a letter and say that my motorhome and my car are my auxiliary aids for disability. And actually the car was a part of my home because it gave me shelter and a place to retreat and go to a quiet space so that I could clear my mind and have peace and not have so much sensory overstimulation from sound. So really they've harmed me, and I can't go get groceries now. I have to walk everywhere, and I do it. I'm not sitting here complaining about that. I'm telling you, I've been harmed, and I don't like what they've done. But to go into this court in Oregon and ask these federal judges and magistrates to act fairly seems to be an impossibility if you're poor. And I want attention brought to this. And I'm pissed off. I'm angry. I'm afraid. And I don't want my family thrown out on the street just because I can't get justice in this court. So if you'll listen to what I say and watch the document that I'm going to put up next, and then go check out the other documents, you'll do me a great favor by mirroring this and posting it everywhere you can. I sure would appreciate it. And thank you so much. And from the bottom of my heart and the bottom of my family's heart, we appreciate and thank everyone who does mirror this video. Thank you so much. United States District Court for the District of Oregon. J. Vincent Shore, pro se, versus City of Portland et al. Defendants. Case number 3-17 CB 1519YY. Plaintiff's response to defendants City of Portland, Portland Bureau of Transportation, and Portland Police Bureau's motion to dismiss in part. Plaintiff's response to defendants City of Portland, Portland Bureau of Transportation and Portland Police Bureau's motion to dismiss in part hereon MTD. Plaintiff J. Vincent Shore, individually and in special and or restricted appearance as trustee of Extramural Church Trust Number 12, approached this court in good faith. Included hereon by reference and incorporated fully herein are the Bill Kia Timmett, document number 14 on the document list, filed October 5th of 2017, and the affidavit attached to the Bill Kia Timmett, and the motion for auxiliary aid for communication disability filed on September 29, 2017, attached hereto as Exhibit A, and the sworn declaration of Dr. Karen Huffer concerning plaintiff's post-traumatic stress disorder, PTSD, and the accompanying communication disability that plaintiff has for PTSD, attached hereto as Exhibit B. Plaintiff also invokes again hereon the demand and need for auxiliary aids as a need certified by Dr. Huffer in her sworn declaration attached hereto, and yet, since this honorable court, quote unquote, ignored the plaintiff's first attempt at equal access with the motion for auxiliary aid, and this quote unquote honorable court ignored it, plaintiff believes that this quote unquote honorable court will again deny plaintiff equal access, for plaintiff. Plaintiff set forth in plaintiff's complaint that defendants City of Portland, Portland Bureau of Transportation, and Portland Police Bureau, collectively city defendants, have created an environment in which transient persons are chased predatorily within the frame of, quote, move ever so often, end quote, which is not a law that exists within the construct of the city code or Oregon statutes, but is often inferred as being actual. Plaintiffs set forth in the complaint that, quote, a reasonable person test would confirm that those who are in constant fear and always on the run from law enforcement cannot reasonably sustain a peacefully improved quality of life, end quote, number 63 in the complaint. Plaintiff's complaint questions the impossibility of performing city defendants' demands as to city defendants' actions of enforcement of their alleged law of move, quote, move ever so often, end quote, and, quote, completely remove a vehicle from the public right-of-way, end quote. Plaintiff also sets forth that when plaintiff invoked the Americans with Disabilities Act and asked for reasonable accommodation from city defendants in the form of a certified advocate that could assist plaintiff in communication with the city defendants concerning the impossibility of city defendants' demands, city defendants failed or refused to accommodate plaintiff. Plaintiff has also called into question city defendants' acts that are believed to be unconstitutional in issuing parking violation citations that condition access to court, a court hearing upon prepayment of a bail, which is outside of due process and equal protection. Plaintiff made other claims in the complaint which are preserved, even though unmentioned in this response to defendant city's MTD. This, quote, honorable court, end quote, granted plaintiff informa pauperis status in this case because plaintiff is absent means to afford litigation or counsel. Plaintiff cannot afford to buy the law. If plaintiff cannot afford to pay an entry fee in this instant case, it would stand to reason that plaintiff cannot similarly afford to pay an entry fee of bail in a parking violation citation case, which is a standard requirement to access a hearing in the Multnomah County Circuit Court concerning parking violation citations. Additionally, plaintiff is unable to hire counsel to assist plaintiff. After this action initiated, plaintiff researched the magistrate, Yulia Yim Yu, the assigned magistrate, Yulia Yim Yu, and discovered that she had spent 9 years prior in the same Multnomah County Circuit Court system that plaintiff alleges upholds and adjudicates the unconstitutional parking violation citations. It is beyond infuriating that plaintiff asked for Ms. Yu to recuse, and this was refused. The conflict of interest of Yulia Yim Yu in this case, with her history, could not be more observable or distinct. Plaintiff's case has been prejudiced by remarks from Judge Marco A. Hernandez in an order dated September 29, 2017, specifically the following remarks. Quote, while the city allegedly has possession of the Dodge Neon, it does not have the motorhome. and the facts do not support a conclusion that plaintiff will be irreparably harmed by the absence of only one of his two, quote, auxiliary aids, sub, end quote. There does not appear to be an allegation that the towing of the motorhome is imminent. Even if there were, the complaint indicates that plaintiff can avoid the motorhome being towed if he moves it to a place where it can be legally parked, end quote. Pages 3 to 4 of the order. Plaintiff demonstrated that the city defendant's tow warnings do indeed threaten imminent towing if not moved within 72 hours. Evidently, Judge Hernandez missed that in the complainant's Exhibit B, or conveniently chose to forget or ignore that as a fact. Hernandez also infers that contrary to plaintiff's complaint, there is a place within the city of Portland where the plaintiff's motorhome, quote, can be legally parked, end quote. In saying this, Hernandez is not only being obtuse, but prejudices plaintiff's case, specifically regarding the matter that the law cannot require an impossibility. If Hernandez is so wise and cocksure that there is a place in the city of Portland where the plaintiff can park plaintiff's auxiliary aid motorhome, plaintiff challenges Hernandez to produce the proof and specify with certainty and authority where this place is. Otherwise, Hernandez is impotent to back up his claim. It can't be both ways. Further, Hernandez, in saying that the facts do not support a conclusion that plaintiff will be irreparably harmed by the absence of only one of his two auxiliary aids, end quote, is either practicing psychology or medicine from the bench, or Hernandez is just being an asshole. Plaintiff's complaint, Exhibit A, which is a letter from Dr. William Korbacher, MD, states that, quote, losing access to these vehicles would be detrimental to plaintiff's overall health and well-being, end quote. The callous presentation of mockery that Hernandez has issued is nauseating and cements that I am without a fair or impartial adjudicator in this court. Plaintiff, in plaintiff's motion for auxiliary aid, listed the internet location of a document for the Guide to Judiciary Policy, which at the time of plaintiff's filing was at, I give the address, as shown by true copies of screenshots from Wayback Machine attached hereto as Exhibit C, which is an internet archive of pages that have been crawled and which shows that this web address page did exist. It has since been moved to another address, listed here, since plaintiff's filing, which is suspect. The court is with notice of the change, however, and is not relieved from its duty to provide plaintiff with auxiliary aid for communication disability. As further evidence below, it seems that the court enjoys moving the location of documents around to confuse pro se litigants or hinder them from their pursuit of justice. It works to effect just that, confusion and hindrance. This plaintiff is surprised that Hernandez hasn't already dismissed this case and sent plaintiff to prison for daring to be poor while having the audacity to approach and ask for justice. Plaintiff motion for assistance of counsel as offered by this court, and this motion was denied without hearing or explanation. Plaintiff invoked enforcement by the United States Attorney General pursuant to 42 U.S. Code 12133 and 12188 in item number 7 of plaintiff's complaint. Crickets continue to chirp on this matter. Apparently, Billy Williams is too busy rounding up marijuana users for victimless crimes to give a damn about the rights of the disabled. Plaintiff motioned and remotioned for injunctive action against the city so that plaintiff could have peace from harassment while this matter was at issue in this court. This court denied that injunctive action twice. Plaintiff, on February 20th, 2018, was again cited with another parking violation citation from city defendant, attached hereto and included hereon as Exhibit D. Plaintiff is now in belief, fear, and apprehension that the city will continue any and all action to aggress upon plaintiff, and plaintiff would be a fool to further pursue this action in court when plaintiff is now induced fear to the point of believing that plaintiff's family are exposed if plaintiff chooses to go forward with this lawsuit by appearing, testifying, or producing evidence that can support plaintiff's case. Plaintiff is without the ability to reasonably trust that the city will allow plaintiff to proceed without threatening to take action up to and including taking plaintiff's shelter and auxiliary aid for disability, the motorhome. This court has endorsed and colluded with the city defendants in the production of plaintiff's induced fear by the actions outlined hereon. For plaintiff to leave his family to attend a scheduled lengthy window to appear in court when the city will be aware of this window, and the city is without restraint or injunctive compulsion to refrain from aggressing against plaintiff during the resolution of this case, would be ludicrous. Plaintiff has absent trust that this court or the city would avoid taking advantage of an opportunity like that. Plaintiff is, by the city's continued action of threat, prevented from attending any official proceeding subsequent to this response. Plaintiff wrote city defendant's attorney, Ashley Carter, who is appearing on behalf of the city defendants, on February the 20th, 2018, and a true copy of that email is attached here too as Exhibit E. The city defendants have not responded concerning plaintiff's fears, and thus the city defendants' tacit agreement concerning plaintiff's February 20th, 2018 email is effective. Again, I see and accuse this court as complicit and colluding with the city defendants in ensuring that I am induced into fear of appearing and proceeding in this matter in repugnance to 18 U.S. Code Section 1512 and with intention and effect of intentionally harassing another person and thereby hindering, delaying, preventing, or dissuading any person from attending an official proceeding. But you can damn well be assured that I won't hold my breath waiting for this, quote, honorable court, unquote, to arrest itself or the city defendants on this matter. Be it known that I am currently with intent and will to avoid any official proceeding now because of your actions. Hey, didn't Sergeant's Towing Incorporated default by not submitting their answer timely? Do you think I'm going to beg you to act on this matter and issue a default judgment against them? Why should I, when you're just going to mock and hinder me? When those who need help come to the persons that purport to dispense justice and instead receive more harm, it doesn't matter if you put robes on it, decorate it with granite walls, set polished furniture about, and call it a, quote, honorable court, end quote. This court is anything but honorable. This court is anything but just. This court is anything but impartial. This court is hereby accused of collusion with my adversary, the city defendants, by and through the involvement of Yulee Gu as having a conflict of interest through the bias and prejudice that Hernandez has shown to my detriment and to the benefit of my adversary. Plaintiff is with fear of even calling in to ask a question, and in following the link to the United States District Court, District of Oregon's CM/ECF help pages, I give the URL here, and show the page where it ends up. Plaintiff finds that the page is, quote, not found, and attached here too as a printed PDF, as Exhibit F, and is directed to a sitemap that ends in the same location that is also not found. Since these two links finalize at the same page, Exhibit F is a PDF print of the final landing of each page. Plaintiff can't even expect help from this court's mismanaged public offerings. If you're going to allow me to proceed in form of pauperous and then deny me equal access thereafter, no attorney, no auxiliary aid for my communication disability, all while allowing my adversary to continue to induce fear and coercion in this matter, which causes me to believe that I have no ability to trust moving forward, then I firmly erect both middle fingers to this court and say, do your fucking worst. I will not bow to your robes. I will not stand for your entrance. I will not attend your pompous, arrogant display that holds no compassion or fairness. I will not salute your title. And though you may kill me or make my family and I permanently homeless, you will not make yourself honorable by doing so. I am no less of an indigent prisoner than was Clarence Earl Gideon of Gideon versus Wainwright, 372 U.S. 335 in 1963.
I'm imprisoned by the societal demands and city defendants' demands that I move, quote, ever so often, end quote, or, quote, remove completely from the public right-of-way, end quote, or face theft of my auxiliary aids. I am just as similarly charged with a crime of existing in society while being disabled as Gideon was for breaking and entering.
I warned you motherfuckers that I needed auxiliary aid when I motioned for a buffer between myself and the court because I'm triggered by court injustice. I practically begged for you to notice that I'm denied access without auxiliary aid. You ignored my motion for help as a disabled person and even mocked me, inferring that I'm okay with the defendant stealing one of my auxiliary aids. Hell, if it's okay for the city to steal and deny me access to my auxiliary aid, of course this fucking court is going to believe that it's morally and ethically responsible to deny me access to auxiliary aid. Just because I asked for it to be under seal didn't mean that I didn't want you to rule on it. Now, Dr. Huffer has testified as to my certified need of auxiliary aids, and I'm betting you're going to ignore an expert witness on the subject also. You're God, and you aren't accountable for any act that you perform while you're in that black robe clown costume. You forced me through your malfeasance of the public trust to be at a disadvantaged triggered state at this matter to the observance and benefit of my adversary. I'm having to bring this demand for auxiliary aids out in front of my adversary and in a triggered state because you refused to protect me while this matter was under adjudication. Your ignoring my pleas for a buffer must mean that you want to hear what I have to say directly, so here it is. I'm afraid, but pissed off. Afraid of society and pissed off at society because society refuses to accept responsibility for creating at least a part of my diagnosed condition while simultaneously telling me to, quote, get over it, end quote, or, quote, you'll be okay if they just take one of your disability auxiliary aids, end quote. That's what was inferred. This is what it looks like to have PTSD from legal abuse. The court is my abuser, and I'm forced to ask you to be fair to me? Fuck that. Kill me if you wish, but I abhor you and the very insinuation that you are just. If you believe that poor or disabled people shouldn't have access to the same constitutional protections that others have, why don't you have the balls to come out and say that instead of hiding behind a robe, sitting in front of a seal, acting as if you're honorable when you're nothing but punks with a title? You fucked me up the ass with a gavel without having the common decency to give me a reach around. Fuck this court for setting all this up, decking it in granite and mahogany and calling it a justice system and then terrorizing and abusing the poor who approach as a last resort. Justice will exist when judges who purport to adjudicate fairly are held accountable for their misdeeds, abuses, and injuries to parties that result from a total absence of integrity in the judiciary. What I see is an injustice system, courtesy of Yuli Yu and Marco Hernandez. And before you do it, which I believe you will, when you deny me the ability to further file electronically in this case, know that my eyes are rolling. My middle finger is even further extended, and it just serves to evidence that you're a fucking machine of egoistic, pompous-ass law degrees without any true ability to adjudicate for poor, indigent scum who aren't approved by your backroom religious meetings of worshipful masters of the temple of unaccountable authority. That's my fucking response to the defendant's motion to dismiss in this fucking kangaroo court from which I have been denied access. I'll be waiting right here.